Well, good afternoon, everyone, and welcome to this Francis Taylor Building Public Law webinar. The topic for today is avoiding judicial review pitfalls. For those of you who don't know me, my name is Richard Honey. I'm a barrister at FTB. Until recently, I was chair of the Public Law Practice Group, but that role has been taken over now by Kate Olley, and we are both speaking today. So we both, you'll be pleased to hear, have experience in bringing and defending judicial review claims, especially in the local government planning and environment fields, but across the whole spectrum of public law as well, and acting for claimants, defendants, and interested parties. So I'm pleased to see that so many people have booked and logged in for the webinar today. You're probably all very familiar with Zoom webinars these days. We'll take questions via the Q&A function on the Zoom system, so you should be able to access that by clicking on the icon at the bottom of the screen. Please do feel free to type in questions as we go. We'll answer questions in a block at the end after the two talks, or at least as many as we have time for. We'll stop at 2 o'clock, even if we haven't got through all the questions, but please feel free to email us afterwards if there are any burning questions which remain outstanding. And all being well, we'll be able to share our screens to show some PowerPoint slides during the talks, and we'll also email out copies of the slides afterwards. We are recording this webinar and intending to publish it on the FTB YouTube channel afterwards. So this webinar is intended to give some practical advice on avoiding judicial review pitfalls. We're going to cover some common errors made by public authorities which lead to judicial review claims, and indeed those made in defending judicial review claims, together with some advice on how to avoid those pitfalls. So I'm going to cover the substantive legal issues, and then Kate is going to cover judicial review practice and procedure. So, as I say, please do type questions into the Q&A function as we go, and I'll move now to the first of the two talks. I've selected three topics where we know that public authorities often run into trouble in practice. We're going to try to flag the pitfalls in these areas and also give some practical tips on how to avoid them. And as you'll see from the slide, I'm going to be covering here three particular substantive legal issues. The first of these is in relation to policy and guidance. So policy and guidance, of course, is often made by public authorities about the legal frameworks that those public authorities have to implement. The courts recognise that that guidance or policy serves a useful function, but for the public authorities drafting the guidance, it's hard to be sure you've got it entirely right when doing so, especially if what we're talking about is a new legal function under a new piece of legislation, for example. So the question that arises is, where you have drafted policy and guidance like this, in what circumstances would it be unlawful? So there's been a fair amount of litigation on this in the last few years, and the answer we've got from the courts is that it's not enough to be unlawful if the policy or guidance just creates a risk of errors or unlawful treatment, and it really does depend on whether the policy or guidance authorises or approves unlawful conduct by those to whom it's directed. So that's the issue that the court will consider. So what are the kind of things that might take an authority over that line? We can give three examples. The first is that policy can't positively approve or authorise unlawful conduct. Secondly, it can't include a statement of the law which is wrong and which would induce a person to breach a legal duty as a result. And it can't purport to provide a full account of the law, but then fail to do that, for example, by misstating the law or leaving out a significant part of the law or giving a misleading picture overall. So you do need to get the law right when writing policy or guidance about that law, but the courts will be quite forgiving of errors made by a public authority when putting policy and guidance together, but within limits. So, of course, then the next stage is what you do with the policy or guidance once it's been published. Now, it's pretty well known that public authorities can't slavishly adhere to policy or guidance. That would amount, for example, to fettering discretion. And public authorities must be willing to consider departing from policy or indeed applying the policy in a modified form, depending on the circumstances of the case. But what about the other end of the spectrum? When do you have to follow policy? And this is another area where there's been a number of cases in the last few years. So the starting point is that public authorities should comply with their policies unless there's a good reason not to do so. But that doesn't apply for all policies, as is often the case in the law. The answer is it depends. So if what you're dealing with is kind of formal policy that's been carefully formulated in a written statement, then there will be a duty to comply with that, absent a good reason not to. And that's especially the case if the policy affects the public. And that's a factor that the court will take into account when deciding whether there's a duty to comply with policy or guidance. But if what you're dealing with is something which is really internal guidance, so it's not public facing, and in particular, it's more administrative than substantive, then it won't necessarily be the case that a failure to follow that guidance or policy without good cause would lead to a decision taken being unlawful. So it's important for public authorities to understand the difference between the different types, as it were, of policy, that which has to be followed absent a good reason and that which can be more readily departed from, because you're going to need to advise from time to time your internal clients about how they have to act in particular cases, for example. So you need to be aware of where the law draws the line. So that's the first topic. Moving on then to consultation. Now, of course, consultation is something of a topical issue. There are moves within the government currently to try to cut down on the amount of consultation and indeed the time taken by consultation. There isn't, of course, a general duty to consult at common law, but you will need to consult as a public authority in three circumstances. The first is where there's a statutory duty to do that, and of course that's usually pretty clear. The second is where there's a promise of consultation or an established practice of consultation, and that gives rise to then a procedural legitimate expectation. Now, it is relatively hard for a claimant to establish a legitimate expectation, but it can happen, and does from time to time, and it's this second situation, it seems to me, that is more likely to trip up public authorities. The third situation is where you have to consult because it would be so unfair as to amount to an abusive process if you didn't. That is exceptional and very rare. So it might still arise in practice, but it is really quite rare to be in that situation. Now, again, consultation is an area where there's been significant litigation in the last few years, and therefore it's an area where public authorities do need to be on top of the law. If you do a consultation, you must do it properly. And there's been litigation about what is therefore a consultation, which attracts the legal duties for fair consultation. So if what you're doing is a formal consultation process, of course, that definitely attracts the legal duties. But if you're doing something which falls short of that, which is, for example, targeted stakeholder engagement, that won't attract the legal duties. So there will be a need to consider the nature of what you're doing, the purpose and the character of the process that might be under consideration in order to decide whether it is consultation to which the duties applies or whether it falls short of that. So authorities will need to think about how far you can go, for example, with stakeholder engagement before the consultation duties kick in, because if they do, you've got to comply with them. So many authorities will want to try to engage with stakeholders in a way that falls short of consultation and therefore doesn't bring the duties. So what consultation requires will depend on the circumstances of each case. So it will vary from case to case. If you're consulting because of a statutory duty to consult, then it's the statutory provisions that provide the context and the purpose for that consultation, and you'll need to understand that to advise on what the fair consultation in that context requires. If it arises by legitimate expectation, then exactly the nature of that legitimate expectation, the past practice or the promise of consultation will influence what will be required in a particular case. Then, of course, we've got the 4 gunning requirements. They are pretty well known, so I will try to take them fairly quickly. The first is the consultation must happen at a formative stage. Now, that's a fairly obvious point, but carries risk nonetheless. And that really is crossing the line between predisposition, which is acceptable, it is okay to consult on a preferred option, across to having a closed mind, to having predetermined the outcome. So it's not a genuine consultation. Of course, this point, particularly the willingness to consider the outcome of the consultation process, links to the 4th gunning requirement, which I'll come on to. Secondly, then, the need to provide sufficient reasons. And it seems to me, from my experience, this is the area where public authorities do quite often run legal risks because they don't provide enough information. Now, the key test from the case law is whether the consultation lets those interested know in clear terms what the proposal is and exactly why it's under positive consideration, telling them enough, which might be a good deal, to enable them to make an intelligent response. So it's got to provide enough information, and that information has got to be presented clearly and fairly and in a way which is complete and not misleading. So this is an area where, in my experience at least, lawyers often have to push public authorities to ensure enough information is provided to meet this second of the 4 requirements. Adequate time, then. Again, another area where lawyers often have to press authorities to allow adequate time, usually because end clients are under pressure to try to move quickly. What is adequate time will depend on the particular facts of each case. So there's no fixed time, and it's an issue which should require consideration and judgment in each case, taking into account the scale of the consultation, the complexity of the issues, who it is that's being consulted, are they experts, are they members of the public? And this also involves fairness, of course, in deciding who to consult. You can't pick and choose consultees, especially not to try to get the outcome that you might want. And then we come to The fourth point, where information is taken into account. And again, this is where public authorities can trip up, especially when they're under time pressure. The court, if a consultation process is challenged or the outcome, the decision or policy is challenged, will expect evidence of consideration being given by the decision maker to important points made by consultees. And that decision maker will need to have been provided with enough information to allow them to conscientiously consider the fruits of consultation and not have any significant gaps in that. And it's important to stress that it's the decision maker, that might be a minister or the board of a public authority agency or a local authority cabinet member or committee. It is the decision maker that needs to give the material the consideration and therefore have the material to do that. Another area which can be risky, because it's often overlooked, is the need to reconsult or amend a consultation process once it's underway. And that might be required by fairness. So if things change, circumstances change, if what the authority is thinking changes or some new factor emerges, then consultation might need to be redone in whole or in part, or some further stage added into the consultation process. And it is often the case that repeating a consultation or adding a further stage to the process is the best overall way to manage legal risk, rather than just pressing on and hoping that no one will challenge it. So defending consultations. Now, helpfully for public authorities, the law is really that something needs to have gone very wrong with a consultation before the court will intervene, but it does happen in practice. So there are things to bear in mind. I've set them out on the slide, but it includes things like you have to take the process as a whole. So you have to take all the criticisms cumulatively. So even if they're relatively small flaws in a consultation process, if they add up to something having gone clearly wrong, the court will have regard to that. But equally, if there's a staged consultation process or some further consultation is done after the main consultation, that might well be enough to cure the problem. So public authorities should be alive to whether there are problems with a consultation process which can be fixed during or through further consultation after the process. And you need therefore to be taking it seriously if consultation responses are complaining about the process in some way. Obviously, you need to take it with a pinch of salt, but you need to be alive to the ability to manage legal risk by developing the process somehow in order to ensure that it is fair overall, even if a part taken in isolation would be very unfair. Okay, so moving on then to the third and final topic that I'm going to cover. That's the public sector equality duty. So I mean, nowadays, most public authorities are very familiar with the public sector equality duty, but it seems to me that it's that familiarity which leads to the risk of errors, because authorities maybe in general are not any longer thinking about the PSED enough. It's become just another box to be ticked, another section where some standard text is inserted in the ministerial submission or an officer's report within local authorities, for example. So it's something which needs more engagement than perhaps it's always given in every case. So a reminder of some of the basics. Consideration of the duty needs to be an integral part of the formulation of the policy or decision. It must be fulfilled before the decision or policy is considered, must be exercised in substance with vigour and an open mind, requiring a conscious thinking about the public sector equality duty and having the decision taken with those goals in mind. And it's not always the case that these relatively demanding standards are met. So I'm just going to run through a bit more of the points that have come from the case law over the years, just to act as a reminder, really. So just referring to the statutory duty is not enough to show that it's been performed. Having regard generally to equality issues, not enough to show the duty has been performed. It requires also properly informing the decision maker before the decision is taken. And this is an area where we quite often see problems because public authorities risk not having enough information to comply with the duty quite often because they're too passive. Albeit the court will cut you a fair amount of slack about how far you go, there will be cases where authorities do need to go out and gather information beyond what they would otherwise have in order to comply with the public sector equality duty. So other points from the case law: requires a proper and conscientious focus on the statutory criteria. Decision maker needs to be clear what the equality implications are precisely, and the consideration of PSED issues needs to be accurate and realistic. And also the decision maker needs to assess the risk and extent of adverse impact and the ways in which that can be mitigated before the decision is taken. Now, of course, there are limits to how far you have to go. It is only a procedural requirement. The public sector equality duty does not dictate any particular result, and it's always going to be for the decision maker to weigh up the various competing factors in making a decision. And the courts have made clear that the public sector equality duty does not require an elaborate structure of secondary decision making. Now, it can often feel like that is what we have through the use of equality impact assessment. But again, equality impact assessment, it seems to me in practice, is not always being as useful as it should be. So there's no requirement in statute to do an equality impact assessment, and there's no prescription anywhere of when an EQIA is required, but it is a helpful tool and in practice will be expected. But public authorities will need to exercise their judgment in trying to decide what requires equality impact assessment, because it's not everything, and there's always going to be a need in practice to act proportionately. There's only so much that resources allow, so it's important to focus EQIA activity on those decisions or policies where it really is necessary. That said, an EQIA is often very useful, in particular because it provides a clear record to demonstrate consideration of the public sector equality duty. So it's more difficult to show in court, if you're challenged, that you've complied with the duty where an equality impact assessment has not been done. But of course, if you do produce an equality impact assessment, and that's the focus of showing compliance with the public sector equality duty, if there's a significant mistake in that equality impact assessment, then in a sense it makes clearer to the court that you've not complied properly with the public sector equality duty, and that might be enough to lead to a decision policy being quashed. So what should you be doing in practice to try to manage the legal risk? Well, it requires specific engagement with those who are potentially affected. It requires information to ensure that you understand the circumstances of those potentially affected, and proper consideration, including of potential mitigation, so that the decision maker can be properly informed and can comply with the public sector equality duty when they come to decide on the decision or the policy. So In conclusion, on these three issues at least, which are, I think, fairly reflective of the approach the law takes generally, the law does not require perfection. And indeed, in practice, the courts do tend to cut public authorities a lot of slack. But even doing what the law does require can often be a challenge for resource-strapped public authorities, especially those that operate in a political context with timelines for decisions and policies which can be challenging. So it's always good to make efforts to try to manage legal risk, but it's not always going to be the case that you're going to be able to avoid judicial review. So it's good to have some advice on how to deal with judicial reviews when it does happen. So this is where I hand over to Kate, who's going to give you some advice on avoiding pitfalls in the practice of judicial review. So Kate, I will hand over to you.
Thank you very much, Richard, and good afternoon, everyone. I will just share my screen. Just bear with me a moment. There we are. So I thought I'd start generally with the issue of rolled up hearings, because Mr. Justice Chamberlain gave some incredibly helpful guidance recently in the Owl hack case, which was about military licenses for Israel. And I know that usually, or at least often, the news that the court has ordered a rolled up hearing doesn't really induce delight on the defendant's side, because of the uncertainty and the inevitable greater resource implications. And it can be unfortunate where perhaps the view is being taken to defend a matter at least to the permission stage, and then the rug gets rather pulled out from under that. But anyway, let's have a look at that. The point at which this judgment was produced, permission for the claim had been refused. There had been a directions hearing, and then there was a rolled up hearing ordered for the oral renewal of the permission application. So Mr. Justice Chamberlain identified 4 key procedural principles that were relevant to what he had to decide. So 4 factors. The first one actually then has 4 points to it, so I'm getting into a bit of rush and dole situation, if you'll bear with me. But here's the first factor. He's really discussing here, we're just giving credence to what the permission stage represents for defendants. So in the vast majority of cases, JR is of course a 2-stage procedure, and the permission stage is supposed to shield a defendant from the burden of having to respond to claims that are reasonably arguable. And so there should be a rigorous approach at the permission stage, scrutinising the claims, to make sure essentially that they focus their resources on the cases that have really got something in them. But there is room for a rolled up hearing, ideally in just exceptional cases. So this is factor 1, and he explained what the court should consider in deciding whether there should be a rolled up hearing. So these are the 4 points. The importance of a quick and final decision. Would a rolled up hearing be likely to result in a final decision more quickly than a separate permission stage? Would a rolled up hearing be substantially longer than a permission hearing? And fourthly, would a rolled up hearing impose a greater burden on the defendant, and if so, how much greater? So looking at those in turn, first one, the importance of a quick final decision. And he said that compared to many types of claim, JRs generally can be dealt with relatively quickly, even where they're not expedited. But there might be cases where there are good reasons for the claim to be determined even more quickly than they generally are. And the case for expedition will be particularly strong, perhaps, where the issues of public importance are raised in the claim, as was the case in that particular case. And so in such cases, a quick final determination the defendant has acted lawfully can serve just as important a purpose in vindicating the rule of law as a final judgment upholding a challenge. Second factor, would a rolled up hearing be likely to result in a final decision more quickly than a separate permission stage? So he said in most cases, permission can be considered on the papers relatively quickly, and if it's refused, a hearing can be listed relatively quickly after that. By contrast, a rolled up hearing will take longer to prepare for and list. If there's a prospect that permission might be refused on all grounds, then a separate permission stage will probably result in a final decision that is quicker than a rolled up hearing. But in some cases, if it's apparent at a fairly early stage, there's a reasonable prospect of permission being granted on one or more of the grounds, then a permission stage might result in permission being granted on some points and not others, with the possibility of an appeal before a substantive hearing, then that could give rise to a complex and potentially lengthy procedure. And in that case, a judge could reasonably take the view that having a separate permission stage would actually elongate the process of arriving at a final decision on the claim and thus order a rolled up hearing. The third point is whether the hearing itself would be substantially longer than a permission hearing. As we know, most permission hearings are given a time estimate of 30 minutes or 1 hour. Obviously, that's less burdensome in all respects for a defendant than a rolled up hearing. But in some cases, exceptional cases, that difference will be more marginal. It might be obvious that if there were to be a separate permission stage, the hearing was going to be substantially longer in length than 30 minutes or 1 hour anyway. And there are cases where permission hearings can last for a day or more. And so the difference between having a rolled up hearing and a separate permission stage is more apparent and real. Fourthly, would the rolled up hearing impose a greater burden on the defendant? If so, how much greater? This Justice Chamberlain said, in most cases, the burden imposed on a defendant at the permission stage is relatively modest, as long as the summary grounds can be concise and there's not much evidence. And obviously at the substantive stage, the burden is greater. But in some cases, especially if those that turn on pure points of law or where the is required is relatively limited in scope, the difference between what's required at a rolled up and what's required at a permission stage might be less pronounced. So those are the four considerations. And then the second factor, the next three factors, factors 2, 3, and 4, and not about rolled up hearings as such, but they may be of interest to some of you. So the second factor was this trend of a rolling approach to judicial review. Fresh decisions are made after the one which sparked the original challenge, and the court said, well, in general, fresh decisions should be challenged by fresh claims. And I remember in the mid-2000s, it was very commonplace, basically in immigration claims, I'm not sure about other areas, for there to be a fresh decision from the Secretary of State, the Home Department, and it was sort of rolled in as a matter of course, really, to the judicial review that challenged the original claim. But the court said that there are still exceptions where that would be appropriate, where a new decision is taken at a late stage in the proceedings and that's challenged, and the public interest demands an authoritative determination of the legality of that new decision as well, rather than waiting for further set of proceedings. The court might take the view that requiring fresh proceedings would just cause undesirable delay, and then would then allow the new decision to be challenged as well by way of amendment to the claim. But even then, there should be careful consideration given to whether the directions should allow for consideration of the arguability of the amended claim before any final or rolled up hearing. The third factor is that the court generally is wary of allowing a claim to be brought where the grounds of challenge are really long and complex. And it's not surprising in the Al-Haq case that he made this point, because I think in the end, the claim ran to some 220 pages and over 500 paragraphs, which made sense in the context, but obviously it fell within the sort of rather extreme end of the spectrum in terms of length. And so judicial review typically involves consideration of the legality of a challenge decision against a wholly or mostly uncontentious factual background. But the utility of judicial review, particularly in fast-moving areas of policy, depends on the court's ability to deliver an authoritative determination within a reasonable time. And obviously, therefore, the scope of the challenge has got to be kept within manageable bounds. Ideally, the statement of facts and grounds should be 40 pages, and the court said applications to exceed that should be approached with caution. And if we've got more than 40 pages, it raises a flag, signalling the need to consider with care whether the scope of the challenge is realistically manageable. So that's a point to raise potentially on the other side if you're faced with an absolutely enormous claim that doesn't respect the 40 pages rule. The fourth factor was that obviously the courts shouldn't give their opinion on academic or hypothetical issues in public law cases, other than in exceptional circumstances where there might be reason in the public interest to do so. Those exceptional cases will involve perhaps a discrete point of statutory construction, which doesn't involve a detailed consideration of the facts, where large numbers of similar cases exist or are anticipated, so that the issue is going to have to be resolved in the near future anyway. But it's much less likely that it will be appropriate to determine an academic dispute which requires the resolution of contentious allegations of fact. So again, that might be an arrow in the quiver to bear in mind as a public authority on the receiving end. My points are in a sense of the yin to the yang. It can be claimants who are more likely to fall into the pits when it comes to procedural points. So I'm setting out some of these as factors to bear in mind and potentially make submissions about against the claimant. So I've got some more points. The rolled up hearing considerations, sort of the main dish on my menu of light bites of procedural points this lunchtime. Moving on to the ever important issue of time limits and promptness. This case of Silver in itself not an exceptional case, but it did give the court the opportunity to summarise again the considerations which go to the issue of the promptness requirement. So when considering whether to grant an extension of time, so the court finds the date from which the relevant time period starts to run, and then considers all the circumstances, and those will include: has there been an adequate explanation for the delay? What is the importance of the issues? What are the prospects of success, particularly important in my experience? Will the extension cause hardship or prejudice to the defendant, or be detrimental to good administration? So the test is not just one of whether there's a good reason for the delay, but the broader test of whether there's a good reason for extending time. And that is likely to bring in many considerations beyond those which are relevant to just the objectively good reason for a delay. In planning judicial reviews specifically, of course, we have the 6-week time limit. An interesting case recently was amalgamated smart metering, where the claim was filed 15 weeks after the expiry of the time limit, and the claimant had failed to act promptly. Well, the claimant said, well, I hadn't discovered that permission had been granted because the local authority didn't consult lawfully, and I couldn't see the application on its website. The extension of time's always going to be a matter for judicial discretion. And in that case, it was held that to extend time would cause substantial and unfair prejudice to the interested party, which was the beneficiary of the permission. And it would also be of detriment to good administration. But I think the key perhaps was that the grounds of challenge were not considered to be so strong as to mean that the public interest in the claim being heard, or decisions about permission being made on a lawful basis outweighed the other considerations. I was actually involved, I'm still involved in a recent case in which time was extended in ostensibly similar circumstances. The claimant didn't know that there had been a prior approval application affecting the land next door, but they did act very promptly once they found out and filed within a week or two. So it's perhaps just bearing in mind that it's not always going to be a get out of jail free card if a claimant is significantly out of time. If they act promptly, then they might just squeak through. That's important to bear in mind as a defendant. I put a note about some statutory ouster clauses under jurisdictional issues. I'm not going to go through that slide, if you'll forgive me, but it's there in case it's of interest to you. The age assessment case of SB and Kensington and Chelsea, the Court of Appeal gave some helpful guidance on how challenges to age assessments should be approached. Some of you may be involved in those. Of course, judicial reviews aren't usually concerned with the merits of a dispute, but the administrative court or the upper tribunal can make findings of fact on age. So procedural unfairness might be critical to granting permission for judicial review, but the court said, well, once that's obtained, then the case should go to the upper tribunal, and then it will consider procedural challenges in the context of the decision generally on the merits, and an outcome on the merits might make an independent decision on procedural challenges unnecessary. And this is the important point. The administrative court should expressly consider whether there is a good reason to hive off a procedural challenge, as in many cases, if doing that would just add to costs and delay in the litigation for no evident benefit. So that might be an important point to raise if this comes up. And I put a point also about the fairly recent statutory reforms caused by the 2022 Act, Judicial Review and Courts Act 2022, implementing a number of reform recommendations, in particular the discretion to suspend quashing orders for a period of time and provide prospective only remedies. And the case in which this came up was the Every Child Protected Against Trafficking against Kent County Council, and I've put the learning from that there. There'll be rare occasions when a departure from the usual approach is justified, and I've explained there what the legal effect is of an impugned act once the quashing order takes place. I'll leave that with you just in the interest of time, and I would just like to end with a note on costs at the permission stage where there is an oral renewal hearing, and again in the interest of saving some of the costs at this stage. So the case of Kofa, the court looked at the position of costs in the context of having heard argument on a rolled up basis and held that the claimant should pay the defendant's costs of its acknowledgement of service and summary grounds, but in the usual way didn't make an order about the costs of the hearing itself, obviously the exceptional circumstances in which the costs of the oral renewal will be payable by the claimant because the defendant isn't required to attend or to spend further costs. Or this is unrealistic perhaps to expect the defendant to sit back and see what happens, but this is worth bearing in mind because it obviously leaves open the usual rule that the costs of the AOS can still be required to be paid by the claimant. Okay, so that's a quick run through of some of the recent issues, and I will I'll stop sharing the screen now. There we go. So thank you very much, everybody.
Excellent. Thank you very much indeed, Kate. So we've got a few questions that people have asked using the online system. If anyone else has any other questions, please do type them in. The first couple were on consultation, so perhaps I'll deal with those first. The first question is, when would you say the consultation is too old and that a further consultation or a part 2 is required? So I'm afraid I'm going to give you the lawyer's answer of it depends, and it really does depend on the facts and the circumstances. The first thing to bear in mind is that the mere passage of time of itself doesn't matter. So in a sense, a consultation doesn't get too old just by the passage of time. But of course, time passing allows circumstances to change or developments to happen or fresh information to emerge, and it's that that matters. The test, in a nutshell, is whether during the consultation process or afterwards, but prior to the final decision making, a new factor or new material emerges which is of potential significance to the decision, so that fairness demands that consultees should be given an opportunity to deal with it. Might also be the case, of course, that the passage of time allows the proposals to change. And if the proposals do change so that they are fundamentally different from what was consulted on, again, you would need to reconsult or do a further consultation at that point in time. But age of itself is not what matters. It is just a number, as they say. What matters is what the passage of time allows to change, and then the impact of that for the fairness of the consultation. Okay, the second question then on consultation is to what extent a specific statutory process avoids the normal consultation requirements. And the truth is there that statute will normally trump the common law requirements on consultation where the statute is either inconsistent with the common law or it provides some specifics. So some consultation processes set out in statute might prescribe a specific consultation period which must be followed, and that applies a separate trumping, as it were, the common law. What I would say, though, is if the consultation period is specified in statute as at least or not less than a number of days, then probably the common law requirements on the right length of consultation would still apply. So in essence, these common law requirements, the gunning requirements, apply on top of the statute and fill the gaps. But they won't apply where the statute provides specifics or is inconsistent with the common law rules. It's also worth bearing in mind that there might be some guidance or published policy which is going to influence one way or the other to either constrain or extend what would be regarded as necessary. So in the same way that statute can affect what consultation should be done, published policy and guidance can as well, albeit it obviously has less force than statute and will tend to be considerations of how, whether it is clear and unequivocal, for example, whether it is qualified or unqualified. So the truth is, when asking what a particular consultation process requires, you need to have regard to all of this relevant material when judging what is necessary, appropriate and fair in any particular case. So, Kate, there's also a question about rolled up hearings, which I'll ask you please to deal with, if you may.
Thanks, Richard. Yes, I've seen that. So I'll just read out the question for everyone. How often will a rolled up hearing result in permission not being given to proceed? So a good question. I can't give a mathematical answer, although I know that 80 to 90% of all claims do fail at permission stage. I don't personally note a greater incidence of permission being given just because there's an oral hearing or because it's a rolled up hearing. I do think the odds are slightly better face to face with the judge than on the papers. That's a bit anecdotal, it's a bit impressionistic. So it will obviously depend on the particular case. I think it also depends perhaps on the type of case, planning, immigration, etc., etc. But it is a bit crystal ball gazing. But I think that's why rolled up hearings are not necessarily great for defendants, because of that greater level of uncertainty. It's all at large, anything could really happen. But I don't think the courts feel under pressure one way or another to give permission or not. Do you have a different perspective, Richard, or would you broadly agree?
No, I would agree with that. I think the thing I would add is that it can be different for different grounds within the same case. So that if there has been a rolled up hearing, a judge will first consider whether a particular ground is unarguable or not, and indeed might say that some of the grounds are unarguable and refuse permission for them. And then other grounds might be judged arguable, and then they will be considered, as it were, the order will then say whether they are allowed or dismissed. So even within the same case, you will get different outcomes in terms of whether or not permission is granted. Okay, so I think that's dealt with all the questions. We're a little bit ahead of time, which is good. So I will just say thank you to you all for joining us, and that I hope you will be able to join us for other public law webinars in the future. And we look forward to seeing you there. Thank you very much.
Thank you.